your license need saving? Do the wise thing. Call Wise Man Lawyers. Does your license need saving? Do the wise thing. Call Wise Man Lawyers. Don't face that court alone. Let the Wise Man team get you back on the road. Does your license need saving? Do the wise thing. Call the Wise Man team at Wise Man Lawyers.
All right, today I'm at Holland Park Magistrates Court. Client was charged with their third drug driving offence in about an 18-month period. There's two types of drug driving. There's the more serious, which is under the influence of a drug, meaning you are literally high on drugs. The less serious is what's called drive whilst relevant drug present. What that means is you've consumed it at some point, the effects have worn off, but there's still traces of it in your system, so you're no longer high, but you've been pulled over, done the roadside test, and it's come back as positive. So basically, my client had been previously done late last year, and on this occasion, there was two incidences of one of being pulled over, relevant drug present, and then a couple of weeks later getting done again. So he's come to me needing me to resolve his second and third, so second and third in total, second and third in 5 years, and second and third in the last 18 months. So basically, if you've got previous in the last 5 years, the laws force the mandatory and minimums and maximums up. So for your first offence of relevant drug present, it's a penalty range of 1 to 9 months. If it's your second, it's a penalty range of 3 to 18 months. And if it's your third, it's a starting point of 6 months with a lifetime maximum. And they are all cumulative, meaning they add on top of one another. So if you go to court and you get sentenced for two different charges of relevant drug present, the penalty you get for the first one adds on top of, or I should say for the second one adds on top of the penalty for the first one. So, and there's few different ways of looking at the law as well. So as I said, your second in 5 years is 3 to 18 months. Third in 5 years is minimum 6. So at face value, it's an absolute best starting point of 9 months. So minimum 3 for the second in time, minimum 6 for the third in time. Cumulative, meaning adding on top of each other, makes minimum 9 months. However, I've got a certain view, and some magistrates, but not all, have the same view, that if you get sentenced for your second and third at the same time, there's technically only one previous for both of them. So even though you've offended in sequence of 1, 2, 3, you're being sentenced in sequence of 1 and then 2 and 3 at once. So literally the conviction for the second and third are at the same moment in time. So for both of them, there is only one previous. Not all magistrates agree with that interpretation of the law, and those that are inclined to think that way do need quite a bit of persuasion. So as a starting point, I said to my client, absolute best case is 9 months. But if there's any room for movement on the law, I'll do it. The other issue is there's what's called a notice to allege previous convictions. If police haven't issued that, there can be room for movement, and they hadn't up until today. So I was hoping to leverage that, but of course the morning of court, they had their T's crossed and their I's dotted and served us with a notice, so I couldn't manoeuvre on that. But the only room for movement on trying to reduce the mandatory minimum from 9 months down was to convince the magistrate that the second and third in time were actually being sentenced in parallel. So technically there was only one previous for both of them. And again, worst case today was a lifetime loss of licence. With regard to preparing, I got him to complete the reformatory course we get all of our clients to do. It can be done online. Got him to get some references that we base all of our that we give to all of our clients, and it lets the people who are going to write the references know who it's going to be addressed to, key bullets are going to cover, etc. Got my client to fill out the online form that we get our clients to fill out that gives us all the information we need. Prepared my submissions prior to today, met the client at court, ran through what was going to happen. We went in, I launched straight into that argument about, the sequences of sentences. So whether or not there was 2 previous for the 3rd offence, or just 1. Convictions, that is, not offences. Ultimately, I was able to persuade the magistrate to get on board with that argument, so he agreed that the 3rd in time, for the sake of sentencing, only had 1 previous, so that allowed me to convince the magistrate that the mandatory minimum for both charges was 3 months. So 3 plus 3 equals 6, as opposed to 3 plus 6 equals 9. However, given there was a properly served notice to allege previous, and given his history was otherwise pretty ordinary, didn't matter how much I jumped up and down, he wasn't going to accept that the minimum 6 months was appropriate. Keeping in mind, the minimum should have been 9 months, but because I won that argument, I convinced the magistrate it was minimum 6 months. However, whilst he wasn't going to give me exactly what I wanted, he only went beyond that by 1 month. So he gave the minimum 3 months for the 2nd in time offence, but he gave 4 months for the 3rd in time offence. So it was a total of 7 months, which is obviously 2 months short of the 9 months that a lot of magistrates may have thought it should have been. And it was 2 months short of what I told the client to expect. So he's elated. He was expecting, well, you know, he'd rung around and spoke to a lot of lawyers, and a lot of them told him that he'd get much more than 9 months, but that's the difference between getting a specialist and someone who does a bit of everything. So he rocked up today assuming 9 months would be the best possible outcome. He's got 7 and very good fines. He's very happy, big smile on his face. I'm Andrew Wiseman at Holland Park Magistrates Court. Thanks for watching. Hi, I'm Andrew Wiseman from Wiseman Lawyers, Queensland's only truly dedicated drug, alcohol and traffic offence law firm. If you face loss of licence, loss of vehicle, imprisonment or anything in between at any court in Queensland, we can and will help you today. This is our specialty. This is all we do. Give us a call, 1300 947 352. I look forward to helping you resolve your issue today.
Don't face that court alone. Let the